Next, from the state capitol, we listen in on a press conference from supporters of a bill that would require divorced parents get at least 35% of their children's visitation time per week. We hear how some parents are currently being excluded from visiting their children following a divorce.
Hello, my name is Stephen Westerfield, Westerfield, President of Illinois Fathers. The mission of Illinois Fathers is to assist non-custodial parents to maintain a meaningful and substantial relationship with their children and educate the general public about the importance of these such relationships. We've brought you all here today to announce our shared parenting bill that we have introduced this year, known as House Bill 5425. What this bill is going to do is give the non-custodial parent a minimum of 35% parenting time per week. Right now, for the specifics of the bill, I'm going to go ahead and I'm going to turn the microphone over to Nurse Richard Thomas, who is one of the drafters of the bill, one of the authors.
Good morning. Thank you for being here. Democracy is greatly enhanced because you are here today. My name is Richard Thomas, Thomas. I am from Loves Park, Illinois. I am a nurse, a veteran. I am a co-author of Illinois House Bill 5425, and most of all, I am a father. I am part of an all-volunteer coalition of organizations representing all women, men, children who are earnestly seeking to minimize the negative impact that divorce and custody battles have on Illinois children. We are here to urge the entire Illinois General Assembly to support House Bill 5425, a shared parenting bill. House Bill 5425 has strong bipartisan support, and that support is growing rapidly. Divorce and separation in Illinois often means that children lose sufficient contact with at least one of their parents and one side of an entire family. There are 168 hours in every week, but most people do not fully understand that the standard visitation schedule for non-custodial parents in the state of Illinois is 4 hours a week and every other weekend. No matter how good and participatory a parent has been, this is the standard time allotted to almost all non-custodial parents. This makes bonding, especially even bonding, next to impossible over the course of a child's first 18 years of development. As a nurse with considerable adult and adolescent psychiatric nursing experience, I have seen firsthand the social, emotional, and psychological havoc wreaked on children and adults who did not receive sufficient parenting time due to court orders. If even bonding is not proactively pursued by family courts, the resulting dynamic may very well negatively impact future relationships as an adult. The social data is overwhelming, revealing that insufficient parenting time is an urgent public health concern. Children who are not evenly bonded to both parents are way more likely to commit suicide, engage in early sexual activity, become pregnant unplanned, have mental health issues, commit crimes, abuse drugs, drop out of school, etc., and so forth. Illinois House Bill 5425, a shared parenting bill, is a quantum leap forward towards a remedy to long, devastating custody battles. House Bill 5425, if enacted, is the biggest improvement in Illinois family law in our lifetime. This gender-neutral bill finally takes the target off the backs of Illinois children going through divorce and custody battles, which all too often go on for years. This bill would give both parents the first 90 days to come to an agreed-upon shared parenting agreement. If they fail to do so, and if the court determines that both parents are good and fit, then House Bill 5425 provides that the non-custodial parent will be allotted at least 35% minimum parenting time weekly to facilitate to enable even bonding with both parents. Based on individual case circumstances, the judge can order between 35% up to 50% parenting time based on the best interest of the child criteria. We have proactively reached out to all potential opposition to House Bill 5425, and we have met with them, or they have refused to meet with us, sadly. We have earnestly tried to address any and all concerns. After an exhaustive search, we have found that there is no legitimate opposition to this bill. The only people who would be against House Bill 5425 are those who have a vested interest in perpetrating and perpetuating conflict at the expense of children. The divorce business is a $50 billion business in this country. That's B with a billion. Most of the tension and conflict in Illinois family law courts is due not only to money matters, but mostly due to custody battles. Tragically, children going through custody battles are the new blood diamonds, the conflict diamonds, who are endlessly mined in all Illinois family courts. Anyone who believes that vested interest has not systematically corrupted the Illinois family law system must also believe that Chicago's Al Capone was only guilty of tax evasion. Conflict equals cash during custody battles, and we can and must do better for our children. House Bill 5425 does not have to be perfect to warrant the full and complete support of the entire General Assembly. There has never been a perfect bill, but House Bill 5425 is the greatest improvement in Illinois family law for the foreseeable future, and we would be the first to revisit House Bill 5425 if enacted to make any amendments that might be needed. In conclusion, we are here to urge the entire Illinois General Assembly to support Illinois House Bill 5425, the only real shared parenting bill in Illinois. And we urge all parents to call their representatives to respectfully insist that they support House Bill 5425. House Bill 5425 is the right thing for Illinois family law and the right thing for Illinois children. And the time to do right is always right now. I thank you, and I'll turn it back to President Westerfield.
Richard. Thank you, Richard. That was awesome. Right now, I'm going to bring up somebody who deals with this on a daily basis. Mr. Michael Gerhart, family law attorney.
Good morning. Thank you for coming here today, and thank you, Steve. And Richard did an excellent job, took lots of details of what the bill is about. But I'd like to say that this bill was not created in a vacuum. What happened was the Illinois Family Law Study Committee, which was formed by Speaker Mike Madigan several years ago, to take a look at family laws and bring them up to date. Now, the Illinois Family Law Study Committee consisted of lawyers, judges, legislators, and experts in the field. And they took a look at all the social science, and they just made recommendations. And this bill, House Bill 5425, like I said, it was not created out of a vacuum by any of the gentlemen here. It was based on the recommendations that came out of Family Law Study Committee. Now, one thing that's real important here to note, although 5425 covers the child custody issues and child visitation, what it didn't do is it did not take out anything that any judicial discretion. The judges still have full discretion to make decisions based on the best interests of the children, and it left in place all the concerns as far as domestic violence. This bill was also obviously designed to take the fight out of custody battles, and so children would not be used as pawns anymore, and that's one of the biggest issues that we have. I would say, and right now we have lots of supporters, as Mr. Westfield pointed out. There are, we have lawyers who are supporting it. We've got judges, we have preachers, we have teachers, everyone across the board. The only opposition I know is, like Mr. Thomas pointed out, those who have some type of interest in creating conflict. And I'll say most of those interests have to do with financial interests. I won't say which group has the most financial interest in this, but we know which ones they are. Thank you for inviting me here, Mr. Westerfield.
Thank you so much, Mick. Next, I'm going to bring up Dr. Sandra Arango-Padron.
Hello there. My name is Sandra Arango-Padron, and I am a mother, first of all, and I am a physician. I am a pediatrician who has domestic violence training and is also an anger management specialist and American Disability Specialist. I am here to ask for the support of House Bill 5425 for shared parenting. I am coming and speaking from a personal and professional standpoint and with a wealth of experience from that angle. I have seen the negative impact that every area of children's lives because they have not had shared parenting. I have seen it affect their emotional, their physical, their psychological, their moral, and their spiritual lives. Oftentimes, when there is no shared parenting and there is a contentious divorce, there is visitation interference that occurs. And when there is less time and there's more of an opportunity for alienation to occur, alienation being child psychological abuse, as it was just recently described in the new DSM-5 in April of 2013, DSM-5 being the Diagnostic Statistic Manual for Mental Health Professionals. It is important to note that because of the stressors that many of these children have because of this child psychological abuse or torture, as many people describe it, to the children and to many of the parents, there are all kinds of consequences that occur. Physically and emotionally, it triggers many times children to have all different types of illnesses, and adults as well, causing, as was mentioned, a national public health crisis. Is what we're seeing. There's all kinds of illnesses that occur from this type of trauma and abuse, such as remembering and knowing many of the instances and patients that I've seen on the ward floor, in the emergency room, and as an advocate. Many of these children and adults will suffer different types of they're immune compromised, autoimmune diseases, diabetes, anxiety, depression. Some of the teenagers we also see with bulimia and anorexia, they are more predisposed to personality disorders and definitely suicide, which is becoming a huge problem where many of the schools are obviously having different type of education to the schools to try and address the increase in teenage suicide. Important to address this and to decrease the fighting and the conflict that occurs in the courtrooms. It is important to note that sometimes the domestic violence that actually occurs in the homes is brought to the court, and the court and some areas there becomes domestic violence by proxy or an extension of some of the previous abuse. And so the ones that are most targeted and afflicted are those children. The children who are innocent and helpless try to voice sometimes what their desires are, and they are not heard. Having them become helpless and more hopeless. That affects their self-esteem, and they feel a lot of shame and guilt, that things that affect them throughout their life. I would like to share that it's easier to grow strong children. It's easier to grow strong children than to repair broken men and women. So if we desire to do better for society and for our children, it is best that we look at what we are doing to society and to our children. There's much more anger and violence happening to the children who have no ability to be to voice and to have that time with another parent and the increased time that they want. And so it is very important that we give that opportunity and put that opportunity for the judges to have that ability to decrease the conflict in the courtrooms and with the other officers of the court. I have to say, speak from a personal point of view as well. I have 4 children. These are the 4 children. And because of the conflict and because of the serious obstruction, I have only seen my children a total of about 4 total hours, about 4 days, in about 4.5 years. They cling to me and they want to be with me, but they don't have a voice. They say mine, mine, mine when they're holding me, and they don't want to let go. So I ask that you support 5425 and minimize the conflict, the false allegations, and the hearsay that step into the courtroom and have no room to be heard, and to have the children ignored. Thank you for listening.
Thank you, Sandra. I want to just touch back a little bit on something that she had mentioned about visitation interference. In 2012, during the 98th General Assembly, we got passed what is known as the Stephen Wadkins bill. This is a visitation interference bill that brings the remedies of visitation interference closer to those with non-payment of child support. And I would like to say that all the effort that we put into this bill to alleviate this problem, it's not being enforced. Law enforcement's refusing to enforce it. The judges are refusing to enforce it, and it's a shame. Next, I'm going to bring up Minister Gwendolyn Chubb.
Good. I think it's still morning. Good morning. My name is Gwendolyn Chubb. I am an ordained minister. I am an early childhood educator, but I stand before you today as the president of a nonprofit organization that does court watching services in domestic relations court. Also, as a mother of 2 children that I have not seen in 6 years. I have no allegations against me, no criminal record, no drug abuse, no history as an alcoholic or a stripper. I am just a mother who happened to be going through a divorce in Cook County, where sometimes the laws that are passed down here don't get enforced in the courtrooms. Having said that, let me touch on my experience in the court watching services that we provide. Because Cook County does not provide court reporters and electronic recording is not allowed, the most that a person can ask for and obtain in court is a bystander's report. We do that because being there to offer spiritual support, we have no dog in the fight. So we're just there to make sure that what's right is going on, and we don't care about who's right. In doing that, what we found is that many couples will come into court and accuse each other of horrible things that they know are not true, and it's only because they want to gain the upper edge or they want to hurt the other parent. This bill would diminish, it would eliminate those couples being able to come in and increase the conflict, because it would give the judge a parameter to start with and negotiate from there. I don't know that it would have helped in my situation with my 2 children, but as a representative of the government of God, I demand, I don't ask and I don't request, I demand that our legislators do the right thing for the people of Illinois who elected them to represent them, for these fine gentlemen here, this mother here, this pediatrician here, all of the other parents who could not be here today, but most of all, for these two right here, Sydney and Ahmad, who have no mother and have no explanation as to why. And I have dedicated my life to hoping with this cause, with helping them to build this coalition, because I don't want another mother, father, uncle, grandmother, no one should ever go through this type of pain. I wake up in the morning and I say, Lord, let this be the day that I get my children back or the day that someone kills me. And that's no way for anyone to live. Pass this bill for these families and these children and for your own right to justice. Thank you.
Thank you, Gwen. Next, I'm going to bring up a young father, Shane Bouvet, area coordinator for the Christian County area of Illinois Fathers.
Hello, my name is Shane Bouvet. I am a 21-year-old father. I have only seen my son 209 hours in 9 months. I've only got to give my son 2 baths. I've never got to read him a bedtime story. I'm not worried about going to the bar, drinking out, going out with my friends. I'm worried about what I can do to be a part of my son's life. I don't want anybody's child to ever go through this, or future generations to ever have to live the life of not being active in their child's life. I hope you please support our bills. Thank you.
Thank you, Shane. That was very brave, brother. I would like to reiterate a little bit on something that I think everybody has mentioned here, and that's investing in the future of our children of Illinois. House Bill 5425 is investing in the future of Illinois' children. Thank you, guys. Yep, we're going to take all questions.
So if
Yes.
the current law isn't being enforced, what is the purpose of passing a new law that won't be enforced? How do
Well,
we make the courts follow the law?
well, that's always going to be a problem, but whenever there's change, that gives lots of judges an opportunity to hang their hat on something instead of doing the same thing we've always been doing. Right now, what we're doing is, a couple hours during the week and every other weekend. Now it's judges take a look and say, okay, this is the new parameter that I have to operate in, and they'll go to that parameter. I mean, right now, we presently have a default, and like I said, that's every other weekend. This would create a different default that, takes the children.
Do you agree that the law isn't being followed? And
Oh, that is a serious problem. I'm going to say in general, it just is a serious problem that judges are not enforcing. And the biggest one that was mentioned here was last legislative session was the visitation interference bill, where we brought in line, the coercive powers of the courts, similar to non-payment of child support, but we're not seeing that being enforced by the courts or by the police. But like everything else, it takes education and time before they start enforcing it. I think, did Richard, I think he had something to add.
I can add to something.
if you wish, so please go up to the mic.
Well, I want to take everybody's word for it, but I mean, we've heard 3 parents tell almost incredible stories of abuse and cruelty. As a family law attorney, what can you do when you go up before a judge that is acting with such, what sounds like insane abuse?
I'm not sure which type of abuse are you talking about? Abuse of the judicial?
Abuse of any kind of common sense. If you were his attorney,
Oh,
her attorney,
obviously I would be stomping in front of the judge because what's part of the problem here that we have is what's being abused is the process, the court process, which is being abused to take one parent out of the life of the child, turning them into a non-entity or minimizing one. And the court process, we have to pick a winner and a loser. Right now, the winner wins big, the loser loses big. What this does is take away the big win, big loss. We have two loving, fit parents. The children have a right to have them in their lives. How do we get past the abuse of the court process? That's a little bit harder. I know there's bills that have been introduced having to do with false allegations, because that is a big problem that we have.
But as you know,
Oh.
words on paper are tidy. Real life is messy.
Correct.
And to build on Terry's question, you know, if it's a abuse and it's unfair to the three parents we've heard from today, how's this bill gonna improve it one iota?
Well, I think part of what they're discussing is the abuse of the court process. And I believe every parent here was accused falsely of something. And once again, the court has to make a determination of who's a winner, who's a loser. And what they did was choose one side, like I said, is a loser, one's a winner. If we have the 35 minimum parenting time, we don't have to worry about the allegations. If somebody knows they're gonna get minimum 35%, I expect that's gonna take lots of the fight out of one parent to accuse the other to win. And that's what we're seeing in court. Somebody has to win. So how do I win? I have to accuse the other one of the most horrendous things I can think of to get the upper hand. If a parent knows they're gonna get 35%, there's less chance that they're gonna accuse the other parent.
Can I ask just a follow-up on that?
Sure.
I don't see how this removes that, because it's 35% unless you're found to be unfit. So won't
Correct.
that, one, incentivize more accusations of being an unfit parent? And
Well-
secondly, how would this impact? The other aspect is the issue of financial support. The custodian parent gets support.
Correct.
How would this impact that issue of support that some might argue, hey, if I'm a single mother, maybe I was a housewife, if the father's gonna get 35%, I'm gonna be diminished in my support level, and I won't be able to survive on that diminished amount, if that is impacted.
Okay, I see some other things here. Fitness, obviously, there's going to be accusation of fitness. Well, what we're helping also is other bills have been introduced having to do false accusations, and hopefully that will address part of the fitness issue. But right now, like I said, it doesn't matter if both parents are fit. One parent is going to have 86% of the time, the other is going to have 14. So you have two fit, it should be, more on the equal side. As far as money goes, the child, do you want to add something on that real quick?
One other thing that this bill is going to do is change the standard from preponderance. So then someone is going to, instead of making these accusations, they're going to have to prove by clear and convincing evidence that them accusations are true. And if you research clear and convincing evidence is very close to that beyond a reasonable doubt in criminal court.
And that's interesting to point out the criminal side, because people are being accused of certain things in court to get the upper hand in divorce court, and the same thing they're being accused of is a crime. But we sit there and we take it in the civil court and we convict them, but we don't take it to criminal court because we know there's not a chance that any prosecutor is going to take this case or convict anybody. It's not even near close. But in the civil side, we don't care, let's go with it, err on the side of caution and all the stuff like that. As far as money, child support, there's a child support advisory committee right now working on the child support laws. And obviously, wherever the child is most, that's where the money goes. Well, the purpose of child support is to support the child. What we have here now is one parent getting more time. Should the other parent get less child support? That's going to depend on lots of different factors. How much time each parent has, how much each parent earns. But along the same line is, if we place the child with one parent most of the time and one parent pays all the child support, we have a problem now. When the child goes to the non-custodial parent does not have assets to take the child and the child should have enjoyable time with either parent. Well, if we put all the assets with one parent, then how's the child going to enjoy the time with the parent who doesn't have the assets? I mean, that is a problem. It's always been a problem.
I'm asking the question, would that support be then divided?
Well-
If one parent, let's make math simple, if got custody and would have been granted $1,000 a month, let's say maintenance or support, would that be cut by 35%, or is there no economic impact?
Well, right now, Illinois has the Child Support Advisory Committee looking at that. We're looking at becoming a shared
Would this
income
bill
state.
specifically
Oh,
impact that?
This bill has nothing to do with the child support side. Child support still stays as is, which I guess theoretically you can say somebody who has a child 14% now is getting it 35%. Well, now they're paying money there, plus they need more support on their side for a child. So yes, it's more difficult with the child, but if we become a shared income state like the Child Support Advisory Committee wants us to become, that will be addressed, and they will have formulas, and they're working through those formulas. We expect a bill out of them, probably a draft will be around June, July of this year. Lots of, the way most of IMD and parents, there's introduction of new Parentage Act, also out of Family Law Study Committee, as well as, recommendations that were here. And they've tried to merge them together, so there is no difference. I'm glad you pointed that out, because I heard statistics the other day. Approximately 42% of children are born out of wedlock right now. And in Cook County, I was told it was close to 80%, and depending what minority group you are, it's extremely high. So whenever we address children, we have to consider, the parentage side, the parents that were not married.
I don't recall the word, I'm using the word unfit. It would be 35% unless you find the other person is
Correct.
not a good parent. What would be the standing to prove that? And to what extent could that then be holding someone up, as we've seen from these individuals, for years in the courts while you're trying to prove whether you're fit or not?
Well, there's lots of judicial discretion on that, and there's going to be case law on what the definition of fit is. Right now, we have, restrict a parent's visitation. We have a serious endangerment standard, and there's tons of case law on exactly what a serious endangerment is. And that still applies with this bill. The judge still has discretion. If there's accusations on fitness, there will be a hearing. We'll go along with that. I mean, it's, like I said, still in the judge's hands.
So to sum up, the system is so broken
Oh,
and so prone to abuse and rewards liars that you've got the situations of these three parents, and what we really need is one more law, and that'll help.
oh, we need more than one more law. Obviously, laws are being introduced on false accusations and stuff like that. Is the system broke? I don't think you're going to get argument from me. How broke it is? My personal opinion, very broke. But we have to move forward. We're seeing these bills being introduced in every state. Right now, the exact same type of bills, the false allegation, the minimum parenting time, the shared income models. We're seeing them introduced everywhere. The people who seem to be against them are those who have a financial interest in not working, and I hate to say it, the bar associations. And the bar associations definitely have a huge financial interest in keeping conflict in the courtroom.
I would like to quickly address several of the issues, to highlight and echo some of the information that's already been put out. Throughout U.S. history, new laws have to be, new mandates have to come from General Assemblies and from Congress to manifest ideas into reality. The 13th Amendment didn't, in reality, give all African Americans the right to vote. It took Voting Rights Acts, several of them, to eventually manifest those ideas into reality. So that is simply the course of history. It is broken systemically, the Illinois family law system. It needs major overhaul. The fact that Madigan appointed a bipartisan commission to do so suggests that. It's been so long before there's been an overhaul and bringing the Illinois family laws into the 21st century. Right now, they're based upon antiquated notions of the family dynamic that no longer serve children to their best interest. As far as child support and visitation, which should be called parenting time in the first place, it's an insult. It's an absolute insult to call a parent a visitor. As child support and visitation is separate and distinct by longstanding court law, as well it should be. No matter how much money in or out of a family dynamic would impact the child's best interest. Best interest stays static. The amount of income is important. Child support is absolutely important. But it's not the most critical thing, because children spell love, T-I-M-E. And with this House bill, they now spell House Bill 5425. And so, just as a personal side note that is applicable to statewide, when I was in an airborne unit, Army airborne unit, jumping out of airplanes to preserve the Constitution, how shocked I was how shocked I was to come back to my home, the land of Lincoln, to find out that the Constitution does not go into Illinois family law courts. They have labeled themselves courts of equity, and significant portions of the Constitution do not go in to the Illinois family law courts. For example, the right to a jury, the right to representation is not in Illinois family law courts, even though your most core existence, your children, and all that you've accumulated through your hard labor is at play from day one when you enter into the Illinois family law system. And so how shocked I was when I received this Constitution that from the President of the United States that was in my left chest pocket as I jumped out of airplanes to preserve the Constitution, how shocked I was to find out the Constitution does not go into Illinois family law courts. That is tragic. And I think the men and women on the front lines today need to be informed that they're laying their life down on the line, only to return to a home which does not recognize, in reality, their constitutional right to parent their own children. Any other questions?
How would this apply if you have parents who move out of the, I mean, let's say you're living in Springfield, you get divorced, one parent takes a job either in Chicago or they get a job in California.
House Bill 5425 has a waiver of the 35% minimum. So the parents can come in and they can waiver the 35%. So say we have a father who's a truck driver. He's on the road all the time. He can't take the children for 35% of the time. There is a waiver of the 35% time. Also, when this bill starts up, the parents have 90 days to come up with their own parenting agreement before the courts would intervene at all. So if the two parents can, within them 90 days, create a parenting agreement, present it to the courts can then say, okay, this is your guys' agreement. Now they can do this through mediation. They can do this on their own. There's systems out there where you can create parenting plans. There's programs online now.
Would there be an exemption if a parent is offered a $100,000 job in LA and they leave Chicago with the kids during the 90% and said, hey, you know, it's obviously in the best interest. There was no agreement, there was no prohibition at that point by the court. How do you get them to come back? And what happens to that 35% once the other parent has absconded with the children out of state?
I think that
Absconded, that is, happens quite a bit, unfortunately. There are presently removal statutes that determine, once again, it goes before the judge, and the judge is going to determine whether it's right or not. The Illinois Family Law Study Committee specifically addressed that, and they had a hard time coming up with the definition of removal. Because right now, removal is anywhere within the state, or you can move anywhere within the state without the court's permission. So you can go from Rockford to Cairo, but you can't cross the border from Chicago to Indiana. So they addressed that by putting a mileage side in it, and that bill, I know, was introduced by Representative Kelly Burke, and that's still out there, that they're working on that part of it. This bill doesn't address that. But we're seeing across all 50 states, the definition of removal is changing. Removal used to be what's best for the custodial parent is best for the kid. Now removal is becoming more of how does this affect the relationship with both parents, and that's what they're looking at.
Would the parent who didn't have the children, if the other parent left for another state, is there any recourse, legal recourse for that parent who's left in Illinois with their job while the other parent left with the children?
Oh, so you're saying they left without permission of the other parent or the court?
I mean, let's say during that 90-day window, they just say, I'm going to take off rather than reaching an agreement with this person I don't like.
Right now, you're not allowed to remove the child during divorce. There's actually a statute in there that says you can't remove a child during divorce. It happens all the time. They go to Wisconsin Dells or wherever, and nobody enforces it. But actually leaving, then the other parent would run into court, and there'd be serious consequences. Some judges treat it, literally change custody like that just because you left without the court's permission. Once again, it's purely judicial discretion. They're going to hear the arguments.
Does it have to be an out-of-state leave, or was that also in-state?
Presently, it's out of state.
Should it be changed?
Within state, like I said, the Illinois Family Law study committee discussed this because obviously
Your opinion, should it be changed?
within state, well, I agree with the Family Law Study Committee. And their recommendation was if anything more, greater than 25 miles. And the reason they picked that was obviously 25 miles is tough because here in rural area, 25 miles is 25 minutes. In Chicago, picking up a child after school would be literally 2.5 hours. So they picked that based on the studies and they did a great job. They interviewed lots of people,
25 miles, it would be kosher, but other than that, you'd have to get permission?
Correct, and that happens right now. When you change school districts, people run into court, discuss the change of school districts. So it's, once again, it's before the judge. If they can't agree, it's going to end up before the judge, just like it does now. Richard, did you have something to add to that?
He's absolutely right that current statutes already cover most of the scenarios that you've already asked. And although we welcome any question, we try to answer any and all concerns because it can be a complex matter if made so. But, there is sometimes those who want you to not pay attention to the Illinois family law system will say cavalierly, glibly, well, it's complicated. That's because they are not looking at the best interest of the child. And in this country, we have a tendency to eventually embrace the complications that come with equality because we realize fully and completely that the greatest and the worst scenario and the greatest complications come from perpetual inequality. And so in regards to the domestic violence issue, which I don't think should even be discussed in this because, first of all, domestic violence, we all abhor it. It needs to be swiftly dealt with, and no one can disagree with that. However, at the same time, this bill has absolutely nothing to do with domestic violence, and I would dare anyone to take their index finger and point to the place in the bill where it impacts the process for which to get an order of protection in any way. It does not impact the process one way or the other. What it does do is preempt a lot of tension, preempt a lot of conflict. So anyone who's concerned about domestic violence should be first and foremost a supporter of House Bill 5425 because it takes the conflict by which a lot of tension, most of the tension is created in family law court. And so with that, anyone else?
Yeah. I receive a lot of emails from our constituents every day, and going back to your question on the child support, I would just like to read this real quick, if I may. Dear Mr. President, I don't know if this actually gets to you or an intern or a paralegal. My story is this. I fathered 3 children, 1 daughter who's now 19, and twin boys who are now 16. I am a decorated war veteran who fought tooth and nail for this country and have never been in trouble with the law, diligently paying child support for these children most of their lives. When I say most, I mean less than 2 or 3 years I have been unemployed here or there, the past 18 years. For every employment I have held, I have paid child support, yet it still isn't enough for the state of Illinois. I am no deadbeat by any means. I have held 2 jobs to keep up with my child support obligations, and until now, I only have 1 employer. I know you don't make the laws, but bless you for being there for us non-custodial parents. As I see it, I only see one way out of this. I have been stressed out beyond the norm. I can't take it anymore. I have tried everything to make ends meet for myself. Now homeless, I have nothing on my hands to think about where I went wrong as I ride the public transportation back and forth. I'm still employed, but I can't afford any rent, where $11 an hourly at full time, I bring home a whopping $250 a week. And then he goes on to list all the things that I'm not going to get into all that because we'll be here all day, but I do want to get down to where he gets back into talking, okay? What all this means is my credit is wrecked for the rest of my life. I will never be able to own my own home, and I'm struggling from day to day. I've been eating at food pantries and sleeping in my car, and by the way, I no longer own the car. While my daughter's mother have been going on cruises, the laws aren't made to ensure that non-custodial parent is doing the fair share of providing for their child. It's punishing. It's punishing them. I'm being treated as though I never paid any child support. I know you have heard all this before as I sit here thinking of how to get any peace. Maybe after I'm gone, the state of Illinois will take another look at how they're running people's lives. Where did I go wrong? I get hundreds of these emails a month, and I don't have an answer for them. The only answer I have for these people is House Bill 5425. When it comes to child support, you know what? I would give every dime that I make every day to have a 35% minimum time with my child. I see my child for 1 hour every other week.
As far as the Illinois Family Law Study Committee, for years, the 35% minimum parenting time was an inextricable part of the recommendations of that Madigan bipartisan commission. We recently found out that at the last second, the 35% minimum, the core, the essence, the soul of that bill was stripped out. We cannot get a straight answer as to who, why, what, or where. But that's the long and short of that. As far as the Illinois State Bar Association, we proactively reached out with them because we want to be able to address all the possible concerns that that would go into impacting from this bill. When we point blank asked them why they're in opposition of the bill and what minimum parenting time they would support for 2 court-determined good and fit parents, the political leader of the Illinois State Bar Association said 0% minimum parenting time because they believe that all decision-making should be 1,000% the discretion of judges. 0% minimum parenting time for court-determined 2 good and fit parents. I'm going to let you form your own opinion about why that is so. And I appreciate the questions. Anyone else want to add anything to that? We have our eminent University of Illinois research analyst, Robert Farrar.
Good afternoon, everybody. I think a common argument used about specifying any guidelines, like 35%, has to do with this notion that there shouldn't be one plan fits all, that it impinges upon judiciary discretion. But the irony is that despite current statutes that calls for reasonable visitation, if you look through a variety of Illinois attorney websites, and if you go through the rules of court published by a variety of jurisdictions around the state, they specify what to expect in terms of visitation. I happened to do a research project where I did browse the internet at various websites published by various attorney sites, Frank and Candid Divorce Info, Divorce Info, Piccone, Reilly and Associates, and they specified what is Illinois standard visitation? And they all said that alternate weekends from 5 to 7 p.m. Various jurisdictions produce rules of court to distribute among attorneys in the district to provide expectations of what the court would do. And I reviewed a half dozen, 6, from the 6th, 16th, 12th, 13th, 11th, and 20th judicial circuit courts. And they all said, for example, the blank shall have visitation with child every other weekend commencing Friday at blank p.m. and ending Sunday at blank p.m. And that's from the 16th. from Will County, guidelines for visitation, alternating weekends from 5 p.m. on Friday till 7 p.m. I can go on and on. They're pretty much very much the same. So much for judicial discretion. One can understand why, considering the caseload that they have to deal with, and they want a degree of consistency. The question for us is, well, is alternating weekends appropriate if you want to foster a meaningful relationship with both parents? And the consensus among experts in the field is unequivocally no, that there isn't enough time or distribution of time for the parent to engage in a variety of activities like helping with homework, preparing the child for school, and et cetera, activities that are considered essential in order to foster a meaningful relationship. So that's why 35%, that is a consensus statement among 110 international experts in the field of child development and divorce studies, that 35%, and it's not that much. Basically, you just extend the weekends to begin, let's say, Thursday and then Mondays. And all of a sudden you're at 35%. And it also helps in terms of conflict because the transition points are no longer at the child's home, but at school. And that minimizes the amount of contact in a high conflict situation where parents have to engage in each other. It's not ideal. It's best to resolve your conflict, but at least it provides the opportunity for the child to have a meaningful relationship with both parents. And that's the key of understanding why 35%. And I'll be more than happy to discuss with any of you offline the research that supports this concept. Thank you.
Well, like I touched on a little bit earlier, House Bill 5425 is the first step in reinvesting in our children's future. We've heard that children from broken homes are more likely to use drugs, to drop out of school, get pregnant, drink alcohol, run the streets. All of these things are happening, and we can see it. They're more likely to commit suicide. House Bill 5425 by no means is a fix-it-all, but this is the very first step towards parental equality in Illinois, and it's high time we reinvest in the children's future of Illinois. Thank you so much.
All right, ladies, thank you for joining us. Relative to the whole custody battle as it applies to parents in the state of Illinois, tell us a little bit just about your own experience and why you're so passionate about the issue.
I'm extremely passionate about the issue because I am a mother of four who decided to go into pediatrics because of my love of children and families, and became an advocate for children of abuse and situations. My children began getting affected when it was 6 years ago when the divorce began, and the children have been alienated so much so that we have no ability to communicate, even by phone, and House Bill 5425 would be a way for families who are beginning divorce processes to be appropriately given the proper amount of time so that the relationships continue long-term. I was a primary caregiver, taking my children to all their activities, field trip mom, all their after-school sports, academic and educational activities, and it has turned our lives upside down and my life upside down, and this type of alienation is now just child abuse, and it's torture, and it's something that we describe in the courtrooms and to the officers of the court and the court, and they continue on hearsay and false allegations without giving proper testimony and evidentiary hearings for there to be truth and justice.
So the
The issue sometimes, and it's going to vary by case, the issue sometimes is that when someone separates, irrespective of whatever the legal requirements are, one parent might poison the minds of the children against the other parent, and that can lead to an alienation. Is that kind of what has happened in your case?
Absolutely, absolutely. When there is an alienating parent, there's a targeted parent, and they will sometimes go to any extreme to alienate and separate the children from that parent, and it's a form of manipulative abuse, and it's harmful to the children. For example, with my children, they didn't even know their nationality. And for me to have taken my 2 older children to our homeland, where my parents were from, and to have placed them in schools to learn a second language and to know the culture, for my 2 youngest daughters to not even know their nationality is just heartbreaking and devastating to know that they don't have that opportunity with their mom, to know their mom or to know their grandparents.
And Gwendolyn, let's, in your case, before we leave, Doctor, I wanted to ask, how long has it been since you've had contact with your children? Over what period of time?
I saw them 3 times, October 27th, November 2nd, and November 9th for 2 hours or less. Prior to that, I had not seen them for a year and a half. And that is because of the manipulative, abusive parenting, the targeted alienation, and the false allegations attempting to keep us separated, and the obstruction within the court system and process.
And Gwendolyn, tell us, if you would, how many children do you have, and over what period of time have you had contact with them since your separation?
Yes, my name is Gwendolyn Chubb. I have 2 children, Sydney and Ahmad. Mommy misses you. And I filed for divorce in January of 2008 from an abusive husband. He had been arrested several times for beating his first wife, and he had gone to jail for beating me, and counseling just was not working. We sought spiritual counsel. It wasn't working. Went to court. I got a temporary order of protection. I filed for divorce. Everything was fine. He got an attorney. He told his attorney, and he told the court in mediation, she should be the residential parent. She's been the primary caregiver. She's been at home. She's been homeschooling our children. I homeschooled my daughter into a gifted school. So he didn't want to fight over the children, and I didn't want to fight over the property. I couldn't maintain the house. I wasn't working. I needed employment. So we just didn't want to fight. Unfortunately, he was already making over 6 figures. He was working for President Todd Stroger of Cook County Board. And I started a new job with Chicago Public Schools, making $57,000 starting pay, plus a $20,000 housing stipend. The attorney saw that and said, okay, we've got to have a way to get them to fight each other. So they went to my husband and said, well, you want your wife back. If you take the kids, she'll come back. So I got an agreed order saying that I showed up to court, gave my 6-year-old and 3-year-old babies to this man who I already said he didn't want them, that I gave them away indefinitely, that I also agreed to a gag order so that I wouldn't go to the media or any government personnel about my marriage or about my case. So I would have preferred that they just call me insane, because who would agree to that? What parent would agree to that? I have been fighting that fraudulent order since 2008. In October 2008, I got another agreed order saying that I agreed to supervised visitation, that all of a sudden I would agree to pay $150 a week to see my children for 2 hours, when I had been the mother and the nurse and the teacher and the doctor and the priest and the everything to them. And it reduced me to a stranger and an outcast. And I've been fighting that ever since.
Someone's going to ask, as I will, how is it possible there's an agreed order when there's no agreement?
That's the question that I've been asking. That's what brought me.
What are you told?
That, unfortunately, in Cook County, that agreed orders don't require a signature or a confirmation that you were actually in agreement or even in court. Last year, in the last General Assembly, I actually proposed a bill, SB 1444, Agreed Orders for Dissolutions Act, asking, can we require agreed orders have the signature of the people who agreed when it comes to things like custody and property and things like that, supervised visitation. Unfortunately, the four sponsors that I had on the bill, they were overwhelmed by the opposition from the Illinois State Bar Association. So Maddie Hunter, Toy Hutchison, Kimberly Lightford, Patricia Van Pelt, all of them just backed away from it. At this point, I have no recourse, no remedy, because there's no false allegations against me. There's nothing I can go back to the court and say, well, I've done this, I've completed this. So there's just no answer. There's no answer. And in the meantime, my children are told on a daily basis, mommy doesn't love you, mommy abandoned you, mommy left you. So there's a cult-like programming that's going on. So even when I do, right now I have no contact with my children, no phone calls, no parenting time, nothing. And when I do get them, what will that relationship be? What will our communication be like? How will they be able to form long-lasting bonds with anybody believing that their mother abandoned them?
Well, there was one other aspect to it. Let's just include, tell us a little bit about your organization, the Court Watching Program. What is it, and why is it that you do this?
Okay, so I discovered that the way that a lot of these statutes are ignored in Cook County is because there are no court reporters that are assigned to the domestic relations courtrooms. When you are able to get a court reporter there, it is up to the judge. So the judge can always say, we're going off the record. And then the court reporter just won't type. So the court reporter can literally sit in a courtroom, state funded, they're paid by the state, by the way, sit in a courtroom all day and not type anything. Then, let's say there's a court reporter and they do type everything that's there. The judge then has the discretion to say, well, you'll have to petition the court each time you want a transcript. Well, isn't that overburdening the court? Isn't that creating an even more hardship on a person who's already indigent? So we wanted to provide, there's no electronic recording allowed. They don't allow cameras in that division only. There is electronic recording in traffic court. There are court reporters in Cook County Criminal Division. So we wanted to provide litigants with some sort of record. So Just Us for Justice Ministry is an organization that God allowed me to start, where we offer court watching services to people. We show up, we provide spiritual support to all faiths, and then we write up a bystanders report. And it doesn't matter who's right. We're there to ensure that what's right takes place. And we offer mediation services. We firmly believe that you shouldn't even handle issues like divorce and custody in a courtroom, which tells you it's adversarial. You should go to your minister. You should go to someone that you respect and that the parents have some sort of trust and relationship built, where they can sit down with that objective third party and say, here are the issues. Let's agree to do what's best for the children. So we do offer that.
Let me ask you, in closing, you've been in and around government before you found yourself in this predicament. Did you ever imagine that there would be government acting in this fashion, or to what extent were you surprised to find out that this was the case?
I actually was telling Nick and the other advocates that this is part of my stress. I have, really high levels of stress going through what I go through, just the heartbreak, the pain of not having my children. But the disillusioning of my faith in America. This is America. This is the standard bearer of justice. I grew up watching films like Eyes on the Prize, and I thought that the legislative, the executive, the judicial branches work the way they say that they do. So to find this out, it's heartbreaking. It is to know that it's ephemeral. Justice is really not there. It's in theory, but in practice, no. And that hurts.
All right. Well, ladies, thank you for joining us, and we wish you well.
Thank you so much.
You're watching the Illinois Channel, an independent nonprofit corporation formed to provide gavel-to-gavel coverage of Illinois state government and other public affairs events taking place across Illinois.